morning and a very warm welcome to the dignitaries and the participants to the official e-platform of Faculty of Law GLS University. This is the opening ceremony of Virtual National Intellectual Property Fest organized by IP Law Clinic under the banner of Faculty of Law GLS University. Faculty of Law has always been the epicenter of spreading knowledge, creating awareness, and working towards the upliftment of humankind, and today is no different. Through this virtual National IP Fest, we aim to outreach to students, researchers, academicians, and professionals with an aim to empower innovators and entrepreneurs. We would also like to enlighten the participants pertaining to the legal ownership of ideas and inventions. We begin this thought provoking, enlightening fest by offering prayer to the goddess of wisdom.
शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरु.
Now it's time to welcome our beloved Dr. Mayuri H. Pandya, the Dean of Faculty of Law, GLS University. Ma'am is our motivational force, the powerhouse at the department, having rich, exceptional, and outstanding 25 years of academic experience. Ma'am, over to you for the welcome address. Ma'am, I request you to unmute.
या देवी सर्वभूतेषु शक्तिरूपेण संस्थिता नमस्तस्यै 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 namo namaha. I bow down to Vidya Shakti, present in one and all present over here, who have joined virtually to the official platform of Faculty of Law, GLS University. On behalf of Faculty of Law, I welcome each and everyone who have joined today for this Intellectual Property IP Fest 2023. A special guest, the chief guest of the opening ceremony, Honorable Shri Devang Nanavati, Senior Counsel, High Court of Gujarat, and Vice President of the GLS University, and the most important, eloquent speaker, youth icon, and the evidence that I can give, sir, is the moment it was declared that the opening ceremony speech is by Devang Nanavati, sir. 1200 plus registrations immediately within 48 hours. That's the eloquent speaker with us. Sir, it is my pride and privilege to welcome you on this e-platform. Faculty of Law is always so much charged and happy whenever you are here. Not only the Faculty of Law, I would go to the extent the entire Gujarat Law Society and GLS University family. We are thankful that you have accepted the invitation and today you are with us. I heartily welcome you on behalf of everyone. I also welcome all the participants across the country who have joined, who have registered, a few of the advocates, the few academicians, I think 54 plus academicians across country who have joined with us, 50 advocates, and the rest, all the budding lawyers across the country who have joined today for this IP Fest. I welcome each and everyone, all the IP clinic members, especially the students and the faculty members of the IP clinic who have worked very hard for this national event. each and everyone who have joined from the Gujarat Law Society and the GLS University, all the office bearers, all everyone who have joined today. I welcome each and everyone on this e-platform. I remember that in 1999, for the first time, the Bar Council of India changed the syllabus, and intellectual property rights became the part of the two subjects that became the part of the curriculum in for the first time in 1999, intellectual property rights and the environmental law. In 1994, as being the part of India, we all of us know that the TRIPS agreement was signed by the country. And from 1994 till the 2023, if we see the entire journey of the entire IP, intellectual, all the rights, everything, you find a sea change. And especially post 2016, because the first policy of the intellectual property rights came up in India. And especially the Honorable Prime Minister of the country, when he declared, for example, the Startup India, Stand Up India, the Make in India, all these, whatever the Make in India, for example, if you think of all whatever was launched by the Honorable Prime Minister, intellectual property rights has to play a very vital role in that. We, being a very responsible stakeholder, being a university, it is our duty to inculcate the culture of intellectual property, especially amongst the budding lawyers. So, with that objective, this 2 years, 2 days intellectual property IP Fest has been organized. I'm proud to say that as in 99 the IP, intellectual property rights, became part of the curriculum, we at the Gujarat Law Society GLS was the first, we were first to introduce the diploma in intellectual property rights in 2000. So keeping the pace on the same track, we organize this kind of awareness programs that so that we can motivate the culture of IP. And I remind the one of the fundamental duty as a citizen of India, the one of the most important fundamental duty is that every citizen of the country should strive for the to have the culture to develop the scientific temper. To develop the scientific temper is one of the most important duty as a citizen of the country. And I think that when we abide by the duty, then we can realize the rights of the intellectual property rights, whether it be as a human right or as a part of the Article 21. So, and as a statutory rights under all the IP. So, with the let us resolve that we abide by to develop the scientific temper, and for that we respect the intellectual property. Today, with us, Devang sir is with us. Without wasting much time, once again, I welcome you, Devang bhai, and each and everyone who have joined us today, eagerly awaiting for your speech. Thank you. Over to Ridhita.
Thank you, ma'am, for the welcome speech. It is my privilege to introduce our chief guest for the today's event, Shri Devang Nanavati sir. Sir is a senior counsel at High Court of Gujarat and practices at the Supreme Court of India. He has won 15 gold medals in his academic career. Sir serves as an advisor at several government and non-government groups and renders pro bono services towards the society and people. Devang sir has special interest in human rights and the laws related to it. Sir believes that every citizen has a deep rooted vision for the betterment and upliftment of the nation. And he firmly asserts that for a progressive nation, it is time to put these ideas and visions into practice. Apart from being an advocate of repute, Devang sir has interest in education and serving society. He is the trustee of the CU Ronak Foundation Trust and also a member of the governing body of Gujarat Law Society. Sir is the founder director of GLS Institute of Professional Training for Law Students and a member of the Ahmedabad Management Association. Sir is perfect in whatever he does, and his pursuits speak volumes about his inclinations towards imparting excellence in the education. In addition to this, Sir has diverse interests in the field of sports such as billiards, snooker, cricket, football, tennis, and many more. He is deeply involved with various organizations like Gujarat State Billiards Association, the Ahmedabad Chess Association, and is also the vice president at Billiards and Snookers Federation of India. With zeal to lead nation and set benchmark in governance, Devang sir has deservingly been ranked amongst top 3 nominees out of the Gujarat's 8 in the Lead India campaign promoted by the Times of India. Sir, we welcome you for an effective, informative, illuminating speech on dimensions of IP in the 21st century, trends, issues, and prospects. Sir, over to you for the address.
Thank you. In the divine presence of Bhagavan Swaminarayan and by the equally divine inspiration of my Guru, Guru Hari Pramukh Swami Maharaj and Guru Hari Man Swami Maharaj, a good morning and thank you to all of you. I thank you all for the rather flattering introduction by both Mayuri Ben and you. Intellectual property is indeed a very, very important subject of law in this 21st century. As the world has grown very, very small, as trade and commerce have transcended international boundaries, and as we, India, are growing up to be one of the world's fastest growing economy and one of the world's largest economies, given naturally our population, especially the age group of our population, where 50% of it is below the age of 25 and nearly 75% is below the age of 50. So we are the world's youngest nation, apart from being the largest. And therefore, it is undoubtedly very important that intellectual property will play a very, very important role as we grow further. India has always been known for its IT services and other areas which are galloping in the 21st century, telecommunications, as I have said, internet services, information technology, computers, softwares, etc. And all these are very, very deeply involved around intellectual property rights. The Prime Minister has also given a lot of boost to innovation, as you know, and the country. And in any innovation, unless you have intellectual property rights protected in their proper perspective, it would be very difficult to move ahead. So there are multitude of reasons why intellectual property is more relevant today than before. It was always relevant. In fact, if one goes to the history, I mean, old civilizations, even the Harappan civilization or Mesopotamia, Babylonian civilizations, they also used to have trademarks on many articles which we have today in our archaeological pursuits found. So it's not that trademark is something unique or a mark is something unique which was used in trade for all these many centuries. And for us, we are a common law following country, the common law being originated from the English. And common law has always recognized the law of trademarks before even it was given statutory form in England and then, of course, across the world, including India. The concept of a trademark is an identification of distinguishing goods and also services. Mayuri spoke about landmark moment in our intellectual property regime, because 1999 was the year when the new Trademarks Act was passed, which is what we follow today. And that Trademarks Act, for the first time, took into its ambit not only goods, because either there to the 1958 Act had only covered products, or not services, goods only. And services for the first time was included in the 99 Act, because as we know, services form a very, very relevant part of our trade and commerce today. So trademark is nothing but, as I said, which distinguishes one person's goods or services provided by him from another. And from this simple concept, of course, a lot of law has developed and progressed. And I'm going to try and touch some of those aspects in more detail. Of course, I'll fleetingly also refer to the other aspects of intellectual property law, that is patents, copyright, and designs. And of course, you have geographical indications also. So geographical indications is a separate world of its own. For example, in Gujarat, we very famously say Surti Khaman, Patanna Patola, and all those, or a Madras idli, or a Madras coffee, things like this, which we are so used to saying in our day-to-day life, are actually now protected by what we know as geographical indications. And they also have a whole regime under the intellectual property law. For those who are students and are embarking upon your journey to learn intellectual property law, this will be quite relevant when you look at it in a separate perspective. But coming back to trademark, so trademark, as I said, is a reputation, is recognition of a reputation which identifies that person's goods and services and distinguishes it from those of others. Um, Colgate toothpaste, or Coca Cola, or Pepsi Cola, or so many examples that one can give, very basic, very nuanced examples which we are used to. In fact, sometimes the mark becomes so popular that the goods get identified by the mark rather than the product itself or the good itself. For example, we very regularly use the word Xerox, and we say, "Yeah, please Xerox this," or "please Xerox, do this." Well, Xerox is actually a trademark. It belongs to a Xerox company. And what you should be saying is photostat copy or photocopy. But actually, the mark has become so popular that we popularly refer it to as a Xerox copy. But actually, it is a photocopy. So basically, the mark distinguishes the good. For example, in India, one of the most popular marks is Amul. When you say Amul, it immediately identifies you with milk, butter, or cheese. And again, it has become so popular that people do ask for Amul rather than that. There is a famous, well, in Gujarat it's very popular. I don't know what in other parts of the country you call it, but in Gujarat you have what we call danani dal, which we have like as a mukhwas or an after meal freshener, mouth freshener. And that, there was a mark which is very well known associated with, called Bhagat danani dal. And it had become so much popular at one stage in Gujarat that people used to go to a pan shop or any shop and ask, "Please give me Bhagat." They never asked for Dharan dal. So the concept of a mark identifies essentially one's goods from the others. Even today, I think, irrespective of what you are served, you will ask, "Please give me a Coca-Cola." And it doesn't matter whether then you are served Pepsi or Thumbs Up or any other of the brands, because the brand has become so popular. So sometimes we see these examples, or I know that villages and small towns, a lot of common people still go up to a provision store and ask that, "Please give me Colgate." Actually, they want a toothpaste, but they are saying, "Please give me Colgate." So these are some examples which show that a mark acquires a lot of reputation. Now, under the new trademark regime, subject to fulfilling certain conditions, you can be declared as a well-known trademark. So the marks, for example, that I have spoken are all which would come within the definition of well-known trademarks. The reason being is that based on certain salutary principles of law, and law is all logic, is that for the ease of convenience and distinguishing goods and services under the Trademarks Act, you have different classes of goods. So depending on what you are producing or what your service is, you fall under a particular class. Of course, these classes are very broad, and one class itself may include hundreds of products or services. But for example, food products, restaurants, for example, toothpaste or other hygienic products or soaps and cosmetics or pharmaceuticals and so on and so forth. There are hundreds of goods which are classified. This is an international classification, and the international classification is then followed even by India while when you apply for a mark in relation to a particular good or service. This is also quite relevant. But the reason I mentioned this is because because when you get a registration of a mark, when your mark is registered in the by the registrar of trademarks on the register of trademarks, it is given for a specific class, and your protection then extends largely to that class. In certain cases, if you are declared as a well-known mark, then you have a right to prevent anyone from using your name, mark, or reputation or goodwill across the classes because you are a well-known mark. So even for example, I were to start, say, a fountain pen business or a ball pen business under the name Xerox. Probably if it is declared as a well-known mark, they could come and injunct me from doing so because it's a well-known mark. And even though the class of products or services may be different, because it is so well-known, you couldn't probably get the right to use that mark even in other goods or products or services. Same goes for somebody like Amul. For example, even if you start Amul pens, I think Amul would, as a well-known mark, be able to prevent you from using that. So these are some of the nuances that probably during the conference, I don't know what the detailed topics of the conference are, but in your journey as an intellectual property lawyer, if you choose to be one, you will certainly encounter these aspects and they will be relevant. So when you embark upon your educational program on intellectual property, do pay special attention to classifications, well-known marks, etc. The basic concept of trademark being that the law does not permit anyone to carry on in his business in such a way as would persuade the customers or clients in believing that goods or services belong to someone else, are his, or are associated with it therewith. It really doesn't matter whether the later person has done this deceitfully, fraudulently, or dishonestly. The fact that your mark is similar, deceptively similar, is the test to the mark of the other person. It automatically, as we use the nomenclature, legal nomenclature, infringes the mark of the other. Essentially, this is a property right, just like your land or your house or your apartment or your office. Whatever property that you own, if somebody encroaches upon that, somebody infringes on your right of property, you have a right to action. So does anyone if they infringe on your intellectual property. Then they have a right, you have a right to stop them from infringing that. That's the essence of a trademark. Trademark can broadly be classified into two concepts further. One is the statutory protection given under the Trademarks Act. So it is a right which is under a statute, the Trademarks Act, and we call it the right to stop infringement of your mark. And your remedy usually is a suit for infringement along with an injunction for infringement. And of course, the right to claim damages if you establish them to your goodwill, loss of business, loss of reputation, etc., etc., on the salutary principles of law of damages. The next right, which is actually considered to be a larger, a broader, and a greater right, which does not require statutory protection, is a common law right of tort. We all know what a tort is. Essentially, a civil wrong for which you can have a remedy, and where you have a right to maintain an action before the appropriate forum for curing that tort or preventing that tort from taking place. So that right of preventing a tort in relation to your mark, your reputation, or goodwill is also known as what we broadly refer to as passing off. Passing off, as the words itself suggest, essentially just symbolize that. Again, the concept remains the same. You can't pass off your goods or services as that of being of someone else. Basically, it's an action in deceit. It's an action which says that you are deceiving people uh, uh, of thinking that they are buying somebody else's goods or services where actually they are not, because that's the law of passing off, which is a common law remedy which does not require any statutory protection. It's available to you under the broad law of torts, which is not codified, so it's not a statutory remedy. As I've said, it's a common law remedy. And again, the reliefs are the same. You can seek an injunction and you can seek damages for that. And then, of course, when you will study intellectual property law in detail, you will understand the overlapping and the small conflicts that arise between the Trademarks Act and the common law remedy of passing off. And then you will come to the tests of passing off an infringement of a trademark under the statutory remedy, where there are some subtle differences. So the most big difference, first of all, in any action for intellectual property, what you have to see is the similarity between the goods or services. So once you arrive at a conclusion that yes, they are similar to each other, the test being of the buyer's or the consumer's perspective, and that consumer has to be the consumer in that line of products. So for example, the test that you will apply to see whether a consumer or a common man will get deceived by a similar mark for, say, as I said, a toothpaste, is quite low threshold, say, as to comparison with a highly sophisticated product of like an iPad, or maybe something more complicated than that, like a road construction machinery or some specific machinery, textile engineering, or so on and so forth. Because the class of consumers that would buy or that are likely to be deceived is different. So you will have to apply the rule of testing similarity from the class of consumers. So if you have toothpaste, you can expect illiterate people, common people, off the shelf people, and your attention while selecting such goods is also less. When you go to buy a toothpaste or a packet of wafer or biscuits or something very ordinary, routine in your day to day life, you are not going to bother too much about paying great detail to, okay, let me pick up, let me see what it is. You will broadly identify, oh, it looks like a Colgate red colored toothpaste with the word C mentioned, and you will just pick it up because it's done in seconds. Whereas if you buy a complicated, expensive watch or something else of that expense, and so the price makes a difference, because the more expensive the thing, you are likely to spend more time in identifying whether you are buying the correct thing that you require or that you want, or that has interested you. So the inquiry of the consumer from the price and the complication and the class of consumers is different. For example, in a sophisticated engineering construction equipment or like a crane, obviously very qualified engineers in that field are going to go and buy. The law is quite different as far as pharmaceutical products is concerned, because there a mistake of picking up the wrong or an inferior drug can sometimes be life threatening. Though of course it is sold on prescriptions, but that doesn't necessarily mean that this confusion is not there. So in pharmaceutical products, the courts have in their judgments been very strict that even if there is some similarity, you should not allow competing marks to be there, because it can really cause serious problems as far as the health is concerned. And passing off is also considered not just to protect the reputation of the owner of the mark, that is a given, but it also is essentially done so that the common man, the consumers, are not defrauded. Because the consumer goes and thinks that he is buying or paying for or acquiring the services or products or goods of a particular brand or a particular owner whom he has great faith. But if there is passing off or infringement, then obviously he is being deceived. So it is also a remedy into that sense in rem and not just in personam. So intellectual property does overlap on the public law remedy to the extent in the law of passing off also, because it protects the class of consumers. So it's a very, very broad field. It is very difficult in this 20-25 minutes that I have to really identify to you uh, all the nuances of intellectual property law. Even one of these topics is good enough to spend hours and hours, and I hopefully you will during this 2-day seminar of yours. Uh, but coming back to it, a landmark judgment came. So there was a judgment which we popularly used to remember as Cadbury's judgment, where the court had distinguished the dissimilarities between competing products. So you had a very famous brand of chocolates that at least some we were aware of it in our junior days. I don't know today's generation. They were called eclairs, and Hindustan Lever and Cadbury essentially fought against each other because they had similar products which were in competing market. And in that case the court held that the dissimilarities that were there were good enough to distinguish the two products, and did not grant the relief of passing off. This was reconsidered and reversed by the Supreme Court in Cadila versus Cadila, when when the Cadila group had split between the two partners of Cadila. They had fought on certain trademark issues, and one of them landed in the Supreme Court. And the Supreme Court, while dealing with this issue, overruled the judgment of Cadbury and SM Dicam, saying that you can't give weightage to dissimilarities. You have to only see the similarities in the goods or services. If the product was, and the test is threefold, it is visually or phonetically. So the mark can be infringed if it is either it looks visually the same, the color combination, the presentation of the mark, as we call it, or the trade dress and trade design of the mark essentially has to be seen for the visual comparison. And the other is the phonetic comparison. So for example, Colgate and Polgate, these are something that would be phonetically very similar to each other, and therefore also falling foul of deceit or passing off or infringement. So Cadila then held that you have to only compare the similarities. Just because there are other dissimilarities, you cannot then essentially protect. I mean, you have to protect the mark. You can't compare the dissimilar things. So this was one aspect. Trademarks also are many. There are word marks. So basically, simply the name, as I've said, Amul, Xerox, etc., ex Colgate, etc. Then there is also a label mark. Label mark is the particular style, design of writing and presenting the mark, the pictorial representation of it. For example, now of course, since the mark is now going to be obliterated, and the company has chosen a new mark, Air India's famous Maharaja, which was its trademark, is no longer going to be used. They have come out with a new brand or logo that's going to be launched soon. So that would be more of a concept of a label mark rather than a word mark. Same way the writings of the word Coca-Cola, as they are written in that running hand style that we are so used to seeing, is again something. Of course, Coca-Cola is also a word mark, but it's also protected by what we would call a label mark. So there are many aspects to a trademark as to how and what form it is registered. Of course, you can't get registration. Trademark has to be essentially a coined word or an invented word, having some nexus with the person who invented it. At the same time, you can't get uh, protection for what we call publici juris words. So for example, you can't get protection for the word Gujarat, for the word India, Bharat, for example, God names, Ram, Sita, Krishna. Though exceptions have been carved out, that in certain exceptional cases where for 50, 100 years, if some mark has become so identified with its goods that even though it uh, relates back to a god name or a common name or a publici juris name, it is granted protection to a limited extent. For example, Ramdev Masalas is a brand which is very popularly known as Ramdev, and Ramdev is the name of a god, as we know, Ramdev Peer, which is very famous in Western India and parts of Rajasthan. But it is granted protection. I think there was a brand in Madras which was known as Sita Cafe or something like that, which has been given protection. There has been a mark called Lakshman Rekha, which has been given protection. There has been a mark called Navratna Pharmaceuticals, which has been given protection, um, and so on and so forth. There are various aspects to marks which have been given protection, even though otherwise, seemingly under the law, they would not be entitled to protection, as they would be using public eye juris works. Sometimes your name, you do business in your own name. For example, one of the biggest examples is Mahindra and Mahindra. So, as we know, the Mahindra family, which promoted this company, is identified with the company trademark, and Mahindra cars and Mahindra tractors and trucks and so on and so forth. And they are very. It's a very popular auto manufacturer, and it has been granted protection even when somebody else named Mahendra uses the name in his corporate name or trademark, because otherwise the law says that you are entitled to use your name. So I cannot be prevented from using my name in my trademark, as my trademark or trade identification or trade name, or as a part of my corporate identity, uh, but with certain exceptions where passing of remedies have been granted or infringement remedies have been granted. So these are some of the interesting features that arise in trademark law. There's also the a new concept which is started to come in, which is the concept of shared reputation. For example, there are, I mean, the classic cases, the Reliance brothers, of course, they had proper agreements to do that. I would have thought so. But Reliance, for example, when the Anil Ambani group and Mukesh Ambani group split, both of them use the word Reliance within their corporate trade names at certain instances. The reason being is that they all did their business together, they come from the same stream, and it can be that two people doing business over a period of time acquire their own reputation, and it is not to be used against each other, but they may be permitted to use what is the concept of shared goodwill. It usually happens in family businesses. um, and it's a complicated law, but at the same time, it is a new development in the field of law, which also needs to be examined. And I'm sure as years go by, it's going to develop more and more. It's probably at a nascent stage in India, at least today. It's And we will go through some, I think, rigors of metamorphosis as far as this aspect of trademark law is there. So there are very interesting topics available under intellectual property for students to explore, to study, to examine, to debate, and I'm sure in this seminar you will be able to do that. Then I think, considering the time, I'm very going to quickly tell you the differences. Copyright is something very similar uh, to the trademark law. In fact, they overlap on many occasions, and therefore, usually before granting a copyright, the trademark registered is checked to ensure that a label mark, is not very similar to the copyright being claimed, because copyright is usually claimed in writing, in paintings, and so on and so forth, even in softwares, because software is nothing but writing a software. So in India, at least, softwares are not protected by patents. In America, it is. Here, software is protected under copyrights only. So copyright, and for copyright, the moment the author or the creator writes it, his copyright is inherent in his work, in his creation. It does not require registration. Compulsory registration is not required. If probably what lecture today I've delivered, automatically I have acquired a copyright for this lecture, and nobody can imitate it without my permission, and I don't need a registration for this. Copyright will start to subsist the moment I have created or I have authored this work of art, as they call it. So copyright is a fundamentally separate act under the statute, and again, the same principles of passing off and infringement apply to copyright. The only difference being is that you don't require registration of a copyright. You will many times see in movies and softwares and books the word C with a circle around it. That's the copyright being claimed in it. Um, then we come to designs. Designs is essentially the shape and the general visual presentation of a particular product. Designs, the law is quite limited and quite strict. If you have already published a design in the public domain, then you can't get protection. For example, the most famous design disputes are with air coolers and their designs. These days, modern air coolers and air conditioners and various other, even planes, aircrafts, and machineries, they would have a particular, even the bottles, for example, the bottle of the Coke or Pepsi or so on and so forth. So you have design protection. Then I've already touched upon geographical indications in the beginning. The last is the patents. The patent is the most complicated, according to me, of the intellectual property rights, the most difficult of the intellectual property rights, even to get and then to protect. And patent is not just based on the concept of using somebody's reputation. Patent is based on creating a monopoly for the inventor. The patent talks about invention, inventor, and novelty. So once you cannot patent something which is already known to the world, it which we refer in the legal language as prior art. So what is already known, like that hydrogen, two parts of hydrogen mixed with, or one part of hydrogen mixed, yes, two parts of hydrogen with mixed oxygen gives you water. But so that you can't patent. But if you add something to that and it creates something else, then yes, that process can be patented, and even the resultant product can be patented. And it's a monopoly that you get, because once you get your patent registered, you get a monopoly. That means that no other person has a right, either if it's a process patent, to use that process in their manufacturing activities, or if it's a product patent, then to sell, market, or otherwise manufacture that product. So patent is a monopoly. It is granted for a limited time. And now the law, originally it used to be 14 years. Now the law of patent 2005 onwards grants you a 20-year monopoly from the grant of the patent date. Uh, and for 20 years, nobody can do it unless they pay royalty to you. You ask for royalty and they pay it to you. So without your license, they cannot violate or use that process or that product using the patented technology as it is known. And patent is considered, since because a lot of innovation, lot of money, lot of time, lot of effort, intellectual effort goes by a person, by an inventor, in producing this patent or this research and innovating and inventing this novelty. Therefore it is sometimes considered to be the highest of the intellectual property rights, and it is given the highest protection as compared to a trademark or a copyright. Because in a trademark or copyright, you can produce the other person's accounts and claim damages. You can show your goodwill and claim damages. In patents, if I have invested hundreds of millions of dollars in research, say for pharmaceutical patent for a medicine, and after 10-15 years of deep research, I have come out with, say, a life-saving drug for cancer or AIDS or anything, and if somebody then copies that patent, infringes that patent, and sells it, he will be able to sell it at a much lesser price than I would have been able to, because I have invested $100 million. I have to recover those costs, whereas he has invested nothing. He's just riding on my hard work, and therefore it has been held that damages alone cannot help a patent remedy, and you will end up having to be given what we call an injunction in a quiet timid action at the earliest. So these are some of the salient features of intellectual property law that I thought I would touch upon to get your lip smacking or create the interest and the tinge in your stomach, to an appetite to have go through this 2 days of the seminar that are going to be there. I hope and wish that you have a fruitful discussion and interaction in the seminar. As usual, my commendations to GLS University, its Faculty of Law, its dynamic Dean Mayuriben and his entire team. You've always done well. You are the leaders in legal education in Gujarat, and we are always very proud of you. And I thank all of you for organizing this seminar. and I thank that you thought it worth to invite me and to speak. I've tried to do as much justice as I can fleetingly to a topic, but a topic so vast, so interesting, and so developing at every stage is very difficult to cover in its entirety in 20-25 minutes. So I will leave the rest of it for your discussions during the two day seminar that you have. Thank you very much for being here on this weekend morning and listening to me. Thank you so much.
Thank you, sir. Thank you very much for such an enlightening session. I'm very sure that our participants have really benefited from the lecture that you have just delivered. Thank you for touching upon all the important concepts as far as IP is concerned, like the geographical indication, the trademarks, the copyrights. Thank you so much, sir. Thank you for citing the judgments as well. Sir, with your permission, there are certain questions. So,
Sure.
if you permit, shall we
Sure.
take up the
Go ahead.
questions?
Yeah, go ahead.
Okay, sir. Okay. So this is the question posted by our student. He says, "How effective, useful is the mediation in solving IPR related issues, sir?"
Um, Well, I mean, mediation is now, of course, made compulsory in commercial suits under the Commercial Courts Act, where all your intellectual property disputes lie. Of course, if you're seeking injunction, then you are not forced to go for mediation in a commercial suit. But mediation always helps. In a commercial dispute, it's always better to settle the dispute rather than fight it for years in court, litigate it, waste money, time, energy, effort, and then at the end of the day be unsure of what result is going to ensue after years of litigation. So it's always better to settle a commercial dispute. However, it can't, I mean, there's no straitjacket formula. It will have to depend on the case. At the same time, if you have not been dishonest in your intention in adopting a mark and later on somebody tells that, oh, I already have a registration or a prior use right in the mark, and it might be better to settle it at the earliest in mediation and change your name or trademark or whatever, so that later on, after you spend 5 years using that mark, investing a lot of money in advertisement and promoting that mark, you suddenly realize that now because of the court order we have to change it. So it's of course useful to go for mediation. There is no harm. Mediations are without prejudice to your rights. So, and if it fails, you can always then come back and litigate. So the mediation is always advisable. I can't have any issues with that.
Thank you, sir, for the answer. So we have one more question. Uh, the participant says that as we currently do not have laws to protect the AI, so how can we know what are the issues of ownership as far as AI is concerned, especially
Probably,
like.
with great respect, not a correct question, because artificial intelligence is a concept which is named, and artificial intelligence is just a platform that provides service. So like he has mentioned, he or she has mentioned GPT, chat GPT. Again, chat GPT, it's protectable as a word mark. If they have a particular design, it's protectable as a label mark. If it has a software that operates it, it's protectable under copyright laws. In America, the whole concept or process of processing your queries and replying it in a particular manner is a patentable service. So I don't know why are they saying that it doesn't have protection. It has protection.
Okay, sir. Thank you for the answer. So shall we take up one more,
Please.
if time permits?
Yeah, that's up to you totally.
Sir, maybe the last question, sir.
Okay.
Whether there should be harmonization or differentiation in IP regimes of different countries. This
Uh,
is the question posted.
this again, probably I can understand a student asking this question, but as he studies his intellectual property, he will know that it is already harmonized. As I said, we follow the harmonized classification list, which is common to what, 160 countries. I am not too sure as to how many have signed treaty, but covers majority of the world's jurisdiction. Same with TRIPS agreement, as was mentioned by Mayuri Ben. Same with the Madrid Protocol, which is mentioned, which is also for the WIPO, which is the World Intellectual Property Organization. So all these organizations, these treaties to nearly 150 countries are signatories to it. So it covers the majority of the countries, and I don't think the IP regime is different in at least the common law countries or the most developed countries of the world. I don't see that. Maybe somebody exception like China may be there, but not otherwise. The enforcement of intellectual property rights may be quite different from country to country, but the regimes are same. So probably in an African country or in some other countries or even in India till about 20-30 years ago, the enforcement of IP regime was quite poor. In India, it has improved tremendously. And I'm sure with the ongoing progress in world economy and the way the world trade and commerce works, I'm sure in these countries also it will come up to speed soon. But harmonization is already there. The enforcement may be different.
Once again, thank you, sir, for answering the questions. Um we move ahead, and I would now like to welcome Dr. Vidhi Shah, Assistant Professor at Faculty of Law, GLS University, to present the formal vote of thanks. Vidhi ma'am, over to you.
Very good morning. What a start of IP Fest. I'm sure that cannot be anything better than the start. Uh, I welcome and a very good morning to all the dignitaries on the e-dais and all the viewers on the e-platform of Faculty of Law, JLS University. On behalf of Faculty of Law, it is indeed the matter of pride and privilege to extend the vote of thanks on the opening ceremony of Virtual National IP Fest. This festival serves as a platform to celebrate and recognize the importance of intellectual property in today's world. We deeply honored to have with us today our esteemed chief guest, Senior Advocate of High Court, Mr. Devang Nanavati, sir. We would like to express our sincere appreciation, sir, for gracing us with this virtual presence and sharing his valuable insight on intellectual property right in the 21st century. Sir's expertise and experience in the field are truly commendable, and we are grateful for Sir's contribution in this event. Sir vividly explained the elementary and grassroots concept of all the IPs in today's session. Thank you very much, sir. I would also like to thank all the GLS Law College family, GLS University family for their virtual presence, all the advocates, academicians, and the budding lawyers who has been participant in the today's session. I heartily thank you for your presence. My sincere thanks to our Dr. Mayuri Ma'am, Dean Faculty of Law, for always believing in us, trusting us, and motivating us to walk ahead in the path of success. I would also like to thank the whole team of Intellectual Property Clinic, students who has worked passionately to make this event successful. Once again, thank you all for being a part of Intellectual Property Fest. We hope that this fest will inspire, encourage further exploration and understanding of intellectual property right. Let us all make the most of this opportunity to learn, network, and celebrate the power of innovation. Thank you so much.
Thank you, Vidhi ma'am, for the extended vote of thanks. Thank you to all the participants. Thank you, Devang sir, for being here for the opening ceremony. The participants are requested now to follow the schedule for the various events that you have registered for. Do join us tomorrow for the closing ceremony and for the announcement of the results. Thank you.